Crown Prosecution Service, Appellant, and Aquila Advisory Ltd, Respondent.
My Lord Stevens will hand down the judgment.
The Supreme Court hands down judgment this morning in the case of the Crown Prosecution Service, Appellant, and Aquila Advisory Ltd, Respondent. This is a brief summary of the Court's reasoning. The appeal raises an important question of law as to whether unlawful acts and dishonest conduct of a company director should be attributed to the company to establish an illegality defence, defeating that company's claim to a beneficial interest in a constructive trust. Mr. Robert Faishney and Mr. David Perrin were directors of Vantis Tax Limited. They exploited their position in breach of fiduciary duty to make a secret profit of £4.55 million. The amount of £4.55 million was also the benefit obtained by the directors from their crime of cheating the public revenue by dishonestly facilitating and inducing others to submit false claims for tax relief. Vantis Tax Limited went into administration. The proprietary rights belonging to Vantis Tax Limited were assigned to Aquila Advisory Ltd. Following the directors' criminal convictions, the Crown Prosecution Service sought confiscation orders against them under the Proceeds of Crime Act 2002. Mr. Perrin was ordered to pay approximately £800,000, and Mr. Faishney was ordered to pay approximately £650,000 to the Crown Prosecution Service. Aquila argued that the directors should be treated as having acquired the benefit of the secret profit on behalf of Vantis Tax Limited, so that the £4.55 million was beneficially owned by Vantis Tax Limited under a constructive trust, and now the beneficial interest in that trust had been assigned to Aquila. Aquila argued that because it had a proprietary claim to the secret profit of £4.55 million, its claim takes priority over the confiscation orders, which do not give the Crown Prosecution Service any form of proprietary interest. If this is correct, Aquila would be entitled to all of the directors' assets, leaving nothing to satisfy the confiscation orders. The trial judge granted a declaration that the amount of £4.55 million was held on constructive trust in favour of Vantis Tax Limited, whose rights had since been assigned to Aquila. The Crown Prosecution Service appealed to the Court of Appeal, contending that the directors' actions should have been attributed to Vantis Tax Limited, and thus Vantis Tax Limited should have been barred from recovering any proceeds of crime because of the principle of illegality. The Court of Appeal dismissed the appeal. The appellant appealed to the Supreme Court on 3 grounds. The Supreme Court unanimously dismisses the appeal on all 3 grounds. In respect of ground 1, the Crown Prosecution Service argued that the Court of Appeal was wrong to conclude that in the case of a proprietary claim by a company against its directors to recover proceeds of crime received in breach of fiduciary duty, the illegality of the directors is not attributed to the company, notwithstanding that the company itself suffered no loss and stood to profit from the illegal acts. However, the decision of this court in Bilter UK Limited against Nazir establishes that a director sued by a company for loss caused by a breach of fiduciary duty cannot rely on the principles of attribution to defeat the claim, even if the scheme involved the company in the fraud or illegality. There can be no exception to that principle in circumstances where the company stands to profit from the illegal acts. This ground of appeal fails. In respect of ground 2, the Crown Prosecution Service argued that the decision of the Court of Appeal is inconsistent with the regime established by the Proceeds of Crime Act. It argued that the Proceeds of Crime Act was intended to permit innocent third-party purchasers who have paid market value for criminal property to keep it, and for innocent third-party victims who have suffered loss because of criminal behaviour to be compensated, in each case in priority to the state, but not to permit third parties to otherwise benefit from criminal activity. However, the overall scheme of the Proceeds of Crime Act is not to interfere with property rights, including the rights acquired by Aquila in this case. Furthermore, there are specific provisions of the Proceeds of Crime Act which allow the state to override property rights, but these provisions were not engaged by the Crown Prosecution Service in this case. There is no inconsistency with the Proceeds of Crime Act, and this ground of appeal also fails. In respect of ground 3, the Crown Prosecution Service argued that even if the unlawful conduct of the former directors cannot be attributed to Vantis Tax Limited, then the trial judge, in the exercise of his discretion, ought not to have granted Aquila any declaratory relief. However, the constructive trust, and thus Vantis Tax Limited's beneficial ownership of the secret profits, arose automatically when the directors breached their fiduciary duties. At no stage did the directors own the secret profits in equity. The trial judge's order recognized this reality and was a proper exercise of his discretion. This ground of appeal fails. The Supreme Court accordingly dismisses this appeal.
Thank you. The court is now adjourned.